ya ya da dun da 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 da. Oh ya ya la la da 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 da. Yan da da dun da da dun da 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 da. Da 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 dun da 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 da. Oh ya 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 la la da 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 da. Oi, 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 oi. Yo la 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 la. Ram bum 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 bum. Ra ra dun 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 dun. Just fixing something. I'm almost ready. Okay. So first of all, I apologize. I should have told you all yesterday that we would have class an hour early today, and I'm sorry I didn't mention that during class. Very sorry. We did put it in today's MailChimp, the AT newsletter, and we put it on the Facebook page, but I always prefer to give you notice the day before. And what we really should have, for all the regulars, when there is some kind of a last minute thing like this, we could just send out a group email. So I don't want to say our email address on the air, but I think all of you have donated, and that means that you got an email personally from me and from Nina. So if you could just send us an email that you'd like to be on the little, group email. It'll just be private. Won't be sharing your email addresses even with each other. It'll all be in the BCC field. But just so that we can send out, if there's a last minute adjustment or cancellation or something of the class, we could send out an email. You won't have to hear about it, just on the Facebook page. I'm sure that would be convenient for everybody. So just email us that you'd like to be on that chat. On that little email group. And if you don't have our email address, just reach out to us through the contact form at accidentaltalmudist.org, and then we'll include you on that. Okay. Second thing was, why did the song not play like it always does? Something weird going on with my phone there. Another gremlin situation. I'll try to get that fixed by tomorrow. Okay, so hello everybody. Great to be with you, and thank you for joining us at an earlier time, 1 hour earlier than normal. Let's light up the darkness. Who's in the house? Renee in Indiana, Shandor in the Bronx, Joe in the Inland Empire, Bill in Mid-Missouri, Lorraine in Texas, Tom in PA. Who's back? Miss me? Yes, we did. Melissa in Great Neck, Yehud in South Carolina, Renee in Indiana. It's so good that you found us anyway. Thank God. Debbie in New Jersey. Shalom on this 19th day. Well, you've already counted. We haven't. So I think it's still the 18th day of the Omer. But East Coast, different. And Ella in Southern California. Aoife in Florida. Chaim in Florida. Welcome, everybody. Okay. Today, with God's help, we're going to finish chapter 1 here in Tractate Makkos and open chapter 2, which is a chapter of particular interest to Nina and I because it's exactly the setting, so to speak, for our next movie that we are working on now. We'll mention that a little later. Okay, so 6b, we're picking this up at the top of 6b here in Tractate Makkos. Chapter 1, this is Mishna number 9. Probably forgetting to say or do something, just a little verklempt. It's very non-stop right now, just constant, everyday interviews, podcast appearances, radio appearances, while at the same time gearing up all the technical requirements, getting our trailer in the right place, the commercial advertising. We've got three publicity teams working, just getting everything ready for the release of Guns N' Moses in the summer, in July. But so you'll be hearing lots more as we get closer to it, but it's just super busy already. Okay, Mishnah number 9, here in chapter 1. In a case where there were two witnesses observing an individual violating a capital transgression, right? So a capital crime for which the punishment is execution. So there were two witnesses observing an individual doing this, and they were observing him from this window in a house. And there were two other witnesses observing him from a window in a different house. And there was one person who was forewarning the transgressor in the middle between the two sets of witnesses. So essentially there's 5 witnesses here. Right? Somebody is committing a capital transgression, something that he'd be subject to execution for this crime, if there are 2 witnesses that are going to testify about it, and he's being forewarned that if you do such and such a transgression, you're gonna be that is a capital crime and you will be executed for it. And then he goes ahead and does it anyway. That's required for him to then be executed. And as we've seen, when we talk about 2 witnesses, as we'll see today, if it's a monetary crime, okay, just 2 people saw it. But if it's a capital offense, the 2 people have to be functioning as a unit. So here we have 2 units, right? A pair of witnesses looking, let's say, into a courtyard where, the rape or the murder is going to happen or is happening. And then 2 other witnesses looking from another window into that courtyard. And a person down in the courtyard saying, if you do that, you're going to be liable to be executed for it. That's the setup. So in such a situation, the law depends on the specific circumstances. What I just said sounds pretty specific, but that's the general situation. So in a situation where some of the witnesses observing from the 2 windows can see each other, right? So there's 2 pairs of witnesses, but can they see each other? Maybe, there's some kind of a column between them so that they can't see each other, but they can see what's going on down in the courtyard. But that's not the situation. Here, at least some of the witnesses can see each other in the 2 windows. Then the testimony of all of these witnesses constitutes one testimony. And that means that if any of these witnesses were disqualified, the whole group would be disqualified. But if they do not see each other, then the testimony of these witnesses constitutes 2 independent testimonies, so that if we, for example, disqualified one witness of one pair because he was related to the defendant, the other 2 witnesses would still work as witnesses. But if they could see each other, then it's all one unit, and one being disqualified would disqualify all 4. Therefore, if there were 2 separate pairs, therefore as 2 independent sets of witnesses, if one of the sets was found to be a set of conspiring witnesses, while the testimony of the other pair remained valid, then both he, the accused of violating the capital transgression, and they, the conspiring witnesses, would be executed. And the second set, whose testimony remained valid, would be exempt because they were not found to be conspiring witnesses. Rabbi Yosei says transgressors are never executed unless his two witnesses are the ones forewarning him, right? It's that you can't have an additional person down in the courtyard doing the warning, according to Rabbi Yossi, and this is the minority opinion that we don't follow. It has to be the witnesses themselves who say to the transgressor, hey, if you do this, you'll be liable to be executed for it, and he does it anyway. They have to be the ones who give the forewarning. Why is warning necessary? We're going to talk about that later. So Rabbi Yosei says, transgressors are never executed unless his two witnesses are the ones forewarning him. As it is stated, quote, at the mouth of two witnesses, he who is to be put to death shall die, from Deuteronomy 17:6, from which it is derived that it is from the mouths of the two witnesses that the accused must be forewarned, and forewarning issued by someone else is insufficient. Alternatively, from the phrase, at the mouth of two witnesses, one derives that the judges must hear the testimony directly from the witnesses, and the Sanhedrin will not hear testimony from the mouth of an interpreter. Now the Gemara. Rav Zutra Bar Tuvia says, that Rav says, from where is it derived with regard to disjointed testimony, in which each of the witnesses saw the incident independent of the other, that it is not valid? It is derived from a verse, as it is stated, he shall not die at the mouth of one witness. So the exposition of this is like as follows. What is the meaning of one witness? If we say that it means one witness literally, well, we already know that you need two witnesses to establish a matter, right? What is the meaning of one witness? If we say that it means one witness literally, we learn it from the first portion of the verse. At the mouth of two witnesses. We need two witnesses to establish a matter. So rather, what is the meaning when the Torah then says one witness? It means that the accused is not executed based on the testimony of people who witnessed an incident with one witness here and one witness elsewhere. Maybe they both saw enough of the transgression to establish that the thing happened, and we'll talk about a case like that. But for a capital case, they have to both see what the other sees. They have to see it as a pair. Whereas in cases of monetary law, the requirements are a little bit less stringent for what the witnesses see and when they see it. Now the Gemara notes, this is also taught in a Baraisa. It is written, he shall not die at the mouth of one witness, from which it is derived to include the law that in the case of two witnesses who observe an individual violating a capital transgression, one from this window and one from that window, and they do not see each other, that they do not join to constitute a set of witnesses, right? In our case in the Mishna, we had two pairs of witnesses at separate windows. Now we're talking about something different. What if we had just two witnesses total, but they weren't standing in the same room, right? They were both watching the same act, but from different vantage points, not together. If they couldn't see each other, they're not a pair of witnesses. That's disjointed testimony. And in a capital case, that would not be enough to have the perpetrator executed. Moreover, even if they witnessed the same transgression from the same perspective, watching the incident not at the same time, but one after the other in one window, they do not join to constitute a set of witnesses, right? So if I look out my window and I see, a guy, I don't know, punching someone, hitting him. And then I go, oh my gosh, there's a guy out there hitting another guy. And I come inside my house and I tell, someone else in the house who's not related to me, hey, there's a guy out there hitting someone. And then meanwhile, I get a phone call. So then my friend goes to the window and he sees, there's a guy out there hitting another guy. But we didn't see the same blows. I saw, a beating that happened earlier in this incident, and he saw a beating that happened later. We didn't see the same beating necessarily. We didn't see it at the same time. If it was a case of monetary law, that might be sufficient. If it was a case of capital law, not sufficient. Rav Papa said to Abaye, why is it necessary to mention both of these cases? Where they saw from two different windows but couldn't see each other, or where they looked through the same window but one after the other. Why do we have to mention both cases? Now, if in the case where one witness views the incident from this window and the other witness views the incident from that window, where the witnesses see the entire incident, both of them, and nevertheless you say that they do not join to testify together as two witnesses, well then if they see the incident one after the other, where this witness sees half the incident and the other witness sees half the incident, is it necessary to say that the witnesses do not join together? So Abaye said to him, yeah, it's necessary to state this law, only with regard to a case where they witnessed one who engages in intercourse with a forbidden relative, incest, which is a continuing act. And each of the witnesses saw sufficient behavior to render the transgressor liable. The Tana of the Baraisa teaches us that even in that case, they do not join to constitute a set of witnesses. Right? I saw two people having sex, and I know that it's prohibited because it's incest. I go tell my friend, oh my God, there's people out there having sex and it's incest, and then he goes and sees it, but we didn't see it at the same time. So even if that was a death penalty case, our testimony wouldn't join, because even though it was one continuous, sexual act, I saw it earlier, he saw it later, and you don't join our testimonies. Apropos witnesses joining to constitute a set of witnesses, Rava says, even if the witness in either window is unable to see the witness in the other window, if the witness in each window sees the one who is forewarning the accused, or if the one who is forewarning the accused could see the two disjointed witnesses, then this group joins to constitute a set of witnesses. Rava says the one forewarning the accused, of whom the sages spoke, need not be a third witness, but even if the victim forewarns the murderer from his own mouth, and even if the forewarning emerge from the mouth of a demon, meaning that the source of the forewarning is unknown, the forewarning is legitimate. Very interesting. We don't have to produce the one who gives the warning in court, as long as the two witnesses saw it, or at least heard it. They saw that the transgressor was warned before he went ahead and committed the transgression. And we don't actually have to see the person who gives the warning. Even if we only hear his voice, it's enough. Rambam says that this idea that the demon issues the warning is a little bit hyperbolic. It just means even if we can't see the source of the voice that is speaking the warning, but why call that a demon? Why not call it an angel? Why not call it a baskol, or just some kind of disembodied voice? Perhaps because the presence of that warning is what then would, carry us over, put us over the top from an offense that could not trigger a death penalty to one that could. So from the point of view of the transgressor who's going to be executed, it sounds like a demon, but to us it's not. Rav Nachman says, disjointed testimony of two witnesses, each of whom observed an incident independent of the other, is valid in cases of monetary law, as it is written, he shall not die at the mouth of one witness, Deuteronomy 17:6. Right? That's a capital case. This indicates that it is only with regard to cases of capital law that disjointed testimony is not valid, but with regard to cases of monetary law, right, damages, that testimony is valid. Why are the evidentiary standards lower in a case of monetary law than in a capital case? Because if the judges make a mistake, we can always get the money back, right? A problem that can be fixed with money is not, at the end of the day, the same quality of problem as a problem that could only be fixed with resurrection of the dead, right? If you execute a defendant, that's permanent. It can't be undone. So, of course, the evidentiary requirements are much more stringent. Wait a minute. Rav Zutra objects to this. But if that is so, and disjointed testimony is effective in certain cases, like monetary law, Well, then in cases of capital law, disjointed testimony should spare the accused from execution. Since one must exploit every avenue possible to prevent executions, in a case where some of the disjointed witnesses were rendered conspiring witnesses, the entire testimony should be voided on their account. Why then did we learn in the Mishnah that if one set witnessed the capital transgression from one window, and one set from the other window, and one set was found to be a set of conspiring witnesses, then he, the accused, and they, the conspiring witnesses, would be executed. The conspiring witnesses, because they sought to have someone killed and they were lying, and the accused, because at the end of the day, the other pair of witnesses were not rendered conspiring witnesses. Their testimony was accepted, and they testified that he committed a murder. So the murderer is executed, and the conspiring witnesses would be executed. But since we're always looking for a way out for a court to pronounce a death sentence, why don't we use this? That some of the witnesses were rendered conspiring, and even call it a disjointed testimony, but use it to excuse the defendant. Why don't we do that? Indeed, that is difficult, according to Rav Nachman. Question is not answered beyond that. New subject. The Mishnah teaches that Rabbi Yosef says perpetrators are never executed unless it is the two witnesses themselves who forewarn him. This is not the law, but this is Rabbi Yosef's view. Rav Papa said to Abaye, and is Rabbi Yosef of the opinion that this line of reasoning is correct and forewarning by the witnesses is indispensable? Really? But didn't we learn in the Mishnah on page 9b of this tractate, we will learn that Rabbi Yosef says an enemy who commits murder cannot claim that he killed the victim unwittingly. Rather, he is executed even if there was no forewarning, due to the fact that his legal status is like that of one who is cautioned and forewarned. So apparently, Rabbi Yosef does not always require that there be a forewarning, right? Hey, if you kill that guy, you're going to be subject to the death penalty, and then he goes and kills, this guy's subject to the death penalty. If there was no warning, then we can't execute him because he wasn't warned. But if the murderer actually is known to be an enemy of the victim, and then he apparently murdered, and that was witnessed, even though there was no warning, here we waive the requirement of a warning because, and this shows you why the warning is necessary, right? Why is the warning necessary? It's not just a legal device so that we can excuse most murderers because rabbinic courts don't want to impose a death penalty. Rather, the warning establishes that the person did it intentionally, right? Without a doubt, we know he did it intentionally because he was warned and he did it anyway. Whereas without a warning, if he did it, maybe we don't really know exactly what was his mens rea, right? What was he thinking? Was it intentional or was it not intentional? We can't be sure. But if there was a warning, we can be sure. But if it was, somebody who ends up killing his own enemy, everyone knows that these guys are enemies, then we have a reason to believe that this was an intentional murder. Abaye said to him, that statement in the Mishnah that you cited that is attributed to Rabbi Yosef is actually the opinion of Rabbi Yosef bar Yehuda. As it is taught in the Baraisa, Rabbi Yosef bar Yehuda says, a chaver, this is one of the sages, someone who's very educated in Torah law, a chaver does not require forewarning, as forewarning was instituted only to distinguish between one who commits a transgression unwittingly and one who does so intentionally. A chaver, it means a friend, but it means a friend of Torah scholars who is a fellow Torah scholar, does not require forewarning to distinguish between them. He knows whether he's doing it intentionally or not. Rabbi Yosef ben Chalafta, whose opinion is cited in the Mishnah here, is of the opinion that forewarning is a necessary prerequisite to executing someone who is judged liable, and that forewarning must be issued not by anybody, but by the witnesses themselves. The Mishnah taught, right? Our Mishnah here, our Mishnah number 9. Yes. The Mishnah taught, alternatively, from the phrase in the verse, at the mouth of two witnesses, one derives that the Sanhedrin will not hear testimony from the mouth of an interpreter. And the Gemara relates, there were certain people who spoke a foreign language who came before Rava for judgment. And Rava installed an interpreter between them and heard the testimony through the interpreter. So that would seem to contradict this holding, this ruling of our Mishnah, that at the mouth of two witnesses means that the judges have to be able to understand what the witnesses are testifying. You can't have an interpreter because, as we all know, that when somebody translates somebody else's speech from one language to another, there is some kind of active interpretation going on. So we need judges who speak the same language as the witnesses. And yet it seems that Rava used an interpreter. Or did he? The Gemara asked, and how did he do so? But didn't we learn in the Mishnah that the Sanhedrin will not hear testimony from the mouth of an interpreter? And the Gemara answers, Rava knew what they were saying, as he did understand their language, but he did not know how to respond to them in their language. He posed questions through the interpreter, but he understood the answers on his own as required by the Mishnah. Apropos disqualified witnesses, the Gemara relates two people called Ilya and Tuvia, who signed as witnesses on a promissory note, were relatives of the guarantor of the loan. And Rav Papa thought to say that since vis-a-vis the borrower and lender, these witnesses are distant and are not related, their testimony on the document is valid. But Rav Huna, the son of Rav Yehoshua, said to Rav Papa, if the borrower does not have the means to repay the loan, doesn't the lender pursue the guarantor to claim his debt? Therefore, the guarantor is party to the loan, and his relatives are not eligible to serve as witnesses on the promissory note. A seeming digression, but since we're talking about disqualified witnesses, it's added here. And that concludes our discussion of Mishnah number 9 here in chapter 1 of Tractate Makkos. We're at the top of page 7a, and now Mishnah number 10, which is a Mishnah and a relatively short Gemara, and with which we will end the chapter. Mishnah 10. This Mishnah continues to discuss the matter of testimony in the case of one who is liable to be executed. Concerning one whose verdict was delivered, and he was sentenced to death, and he fled, and he then came before the same court that sentenced him. They do not overturn his verdict and retry him. Rather, the court administers the previous verdict. I mean, that's what we want, right? We don't want that just because somebody was tried for a crime, found guilty, sentenced to be executed, and then he managed to escape between, leaving the courthouse where he was sentenced to die and the place of his execution. He escaped. Then we catch him again. Because he escaped, we're going to now do a whole new trial? No, of course not. We've already tried him and found and sentenced him to be executed. We should keep the verdict in its place. They do not overturn his verdict and retry him. Rather, the court administers the previous verdict. Consequently, in any place where two witnesses will stand and say, we testify with regard to a man named so-and-so, that his verdict was delivered, and he was sentenced to death in the court of so-and-so, and so-and-so and so-and-so were his witnesses, well, that person shall be executed, right? These witnesses don't come to testify that they saw the crime. These witnesses come to testify that they saw the trial. This is the guy. He was tried in this court by these judges with these witnesses, and they found him guilty, and we come to testify that. According to that testimony, we can now execute this man. The Mishnah continues. The mitzvah, right? Mitzvah, and always remember that mitzvah, it's often used to mean a good deed, but it's a good deed because we're fulfilling our obligation. Mitzvah means commandment, right? So when we do a mitzvah, it's because we are fulfilling a commandment that God imposed on us. The mitzvah to establish a Sanhedrin with the authority to administer capital punishments is in effect both in the land of Israel and outside the land of Israel. A Sanhedrin that executes a transgressor once in 7 years is characterized as a destructive tribunal. Interesting, here in the Koran Talmud, the translation is a destructive tribunal. In the Art Scroll, I remember very well, because I was so struck by it, they translate this as a murderous court. Right? So a Sanhedrin that executes once in 7 years is deemed a murderous court, like a bloodthirsty court. Like, wow, they are quick to execute. Rabbi Elazar ben Azariah, who we read in the Passover Haggadah, right? Elazar ben Azariah says this categorization applies to a Sanhedrin that executes a transgressor once in 70 years. So seemingly, what Elazar ben Azariah is saying is that we are so reluctant to impose a death penalty as a court, because we could be wrong and then we would have killed an innocent person. We're so reluctant to issue a death penalty that if a court does so once every 70 years, we call that court a murderous court, or in this translation, a destructive tribunal. Rabbi Tarfon and Rabbi Akiva say, if we had been members of the Sanhedrin, we would have conducted trials in a manner whereby no person would have ever been executed. Rabbi Shimon ben Gamliel says in adopting that approach, they too would increase the number of murderers among the Jewish people. The death penalty would lose its deterrent value, as all potential murderers would know that no one is ever executed. You can't be, right, such a compassionate judge who's so afraid to get a death sentence wrong that you never impose a death sentence, which the Torah does require that judges do. And if you're never willing to impose a death sentence, then there will be no deterrent effect, and therefore more innocent people will be murdered. You can't be so compassionate. Old saying, right? If we are cruel, if we are kind to the cruel, we will end up being cruel to the kind. That is the Mishnah. Now, what was interesting about this is that Rabbi Shimon ben Gamliel said, in adopting that approach, they too would increase murderers. So when he says they too, who's he saying first, right? Is he saying that Rabbi Elazar ben Azariah would increase murderers? Is he saying that the Mishnah, the anonymous Tana of the Mishnah, is being murderous? Because he's saying that we're so reluctant to issue death sentences that makes our court murderous in the sense that it multiplies murders in the land because the court is not taken seriously. We'll see. Okay, that was the Mishnah. Now the Gemara. The Gemara infers, it is in the case of one who comes before the same court that they do not overturn the verdict. But, right, so now back to the first point of the Mishnah, that if witnesses come and say, we saw this guy's trial, he was sentenced to die, then he escaped. So the only thing that's lacking with him is execution. He doesn't need to have a new trial. So it's in the case of one who comes before the same court that they do not overturn the verdict. But if one comes before a different court, they overturn the verdict and they retry the case. The Gemara asks, but isn't it taught in the latter clause of the Mishnah? Any place where two witnesses will stand and say, we testify with regard to a man named so-and-so, that his verdict was delivered and he was sentenced to death in the court of so-and-so, right, the judge, and so-and-so and so-and-so were his witnesses. Well, that person shall be executed on the basis of the testimony. This indicates that the verdict is not overturned and the defendant is not retried before another court. So why are you saying that if he's brought before a new court, we have to do a whole new trial? And Abaye said, this apparent contradiction is not difficult, as here in the first clause of the Mishnah, from which it was inferred that the second court overturns the initial verdict, it is referring to a case where the initial verdict was outside the land of Israel, and then the defendant came before a court in the land of Israel. But there in the latter clause, which indicates that the second court sustains the initial verdict and does not retry the defendant, it is referring to a case where the initial verdict was in the land of Israel, where presumably the judges are of a higher caliber and more, we're going to trust their verdicts. And the case subsequently came before a court outside the land of Israel. They would honor the verdict of the judges in Israel. And this is as it is taught in a Baraisa that Rabbi Yehuda ben Dostai says in the name of Rabbi Shimon ben Shattach, if a convicted defendant fled from Eretz Yisrael, the land of Israel, to outside the land of Israel, one does not overturn his verdict. Rather, they implement his initial verdict. But if one fled from outside the land to inside Eretz Yisrael, one overturns his verdict and the defendant is retried. And perhaps due to the merit of Eretz Yisrael, the court will discover a reason to exonerate him. not so much about the status of the judges, but the fact that he made it to Israel. Perhaps the merit of being in Israel and the court being in Israel, something will be found that was overlooked before, which will exonerate him, and we won't have to execute, which the judges would always rather not execute. The Mishnah teaches the mitzvah to establish the Sanhedrin with the authority to administer capital punishment is in effect both in Eretz Yisrael and outside Eretz Yisrael. So the Gemara clarifies, from where are these matters derived? It is as the sages taught. It is written with regard to the sentencing of murderers. And these shall be for you as a statute of justice for your generations in all your dwelling places. Numbers 35:29. From which we learn that the mitzvah to establish the Sanhedrin is in effect both in Eretz Yisrael and outside Eretz Yisrael. Now, think about that. A Sanhedrin is a court of 23 judges, and a great Sanhedrin is 70 judges. Why do we need a lesser Sanhedrin, right? The first level Sanhedrin for capital cases. So what we're talking about here is capital crimes where the court is going to issue a sentence to execute the defendant. If we're going to say that we're establishing Sanhedrins outside the land of Israel, that means that according to Torah law, there should be a rabbinic court operating in other nations, right? Under where they're residing in another nation, subject to the laws of that nation. But if a Jew is found guilty of a murder that would result in his execution in the land of Israel, tried by the Sanhedrin, then it should produce the same result that he's tried by a Sanhedrin outside the land of Israel. Most courts in other countries look down upon some private body not recognized by the government of that country passing a death sentence and carrying out an execution. For that reason, we say that Dina de Malchusa Dina, the law of the land is the land, right? And we won't have a Sanhedrin try, sentence, and execute someone for a capital case in a place where that's just not permitted and could cause tremendous difficulties for the entire Jewish population in that country. But technically, we should do that. If so, what is the meaning? From which we learn that the mitzvah to establish a Sanhedrin is in effect both in Eretz Yisrael and outside Eretz Yisrael. Well, if so, what is the meaning when the verse states, judges and officers shall you appoint in all your gates? Deuteronomy 16:18, which indicates that the mitzvah to establish a Sanhedrin is in effect where the gates are yours, i.e. in Eretz Yisrael. So the explanation is as follows. In your gates, in Eretz Yisrael, you establish courts in each and every district and in each and every city. Outside Eretz Yisrael, you establish courts in each and every district, but you do not establish courts in each and every city, because you may not control that city. The requirement to establish courts in every city, this is only in Eretz Yisrael. Now, the Mishnah teaches a Sanhedrin that executes once in 7 years is characterized as a destructive tribunal. Rabbi Elazar ben Azariah says this categorization applies to a Sanhedrin that executes once in 70 years. A dilemma was raised before the sages. Is Rabbi Elazar ben Azariah saying that a Sanhedrin that executes once in 70 rather than 7 years is characterized as a destructive tribunal, right? That even if they only kill once in 70 years, that's still too much, right? A murderous tribunal. They should do it less often than that. Or perhaps he is saying that standard conduct is for a Sanhedrin to execute once in 70 years, and only if it executes more than one person during that period is it characterized as destructive, and the Gemara concludes that dilemma shall stand unresolved. Is it once in 70 years? That's what we're looking to do. And less than that is also a problem because we're not setting an example, a deterrent example. So there should be at least once in 70 years. But more than once is bad. And we're sort of looking for that one case. Is he saying that? Unclear. The Mishnah teaches that Rabbi Tarfon and Rabbi Kiva say, if we had been members of the Sanhedrin, we would have conducted the trials in a manner where no person would have ever been executed. And the Gemara asks, well, how would they have acted to spare the accused from execution if witnesses testified that he intentionally committed murder? and Rabbi Yochanan and Rabbi Lazar both say that they would have asked the witness, did you see whether the accused killed a treifa, meaning a person with a condition that would have led to his death within 12 months, or if he killed someone who was intact? And the law, the legal status of a treifa, a person who's going to die anyway, is like that one of who's already dead, in the sense that one who kills him is not executed. Since no witness can be certain with regard to the victim's physical condition, they would invalidate any testimony to murder. Now, note that it is not permitted to shorten anyone's life, even if they're on their deathbed and dying. You're not going to be subject to execution for it, but it definitely violates the law. You'd not be subject to execution. Now, what they're saying is no one, before they committed murder, and even after the murder was committed, we're examining the victim, would we have been able to establish, they didn't have autopsies in the ancient world like we do now, that this person was going to die anyway. They're just saying we would create that doubt, and on the basis of that doubt, we would, not execute the defendant, because Rabbi Akiva and Rabbi Tarfon are just fully reluctant to ever pass a death sentence. Rav Ashi said, well, even if you say that they examined him post-mortem and he was intact, the testimony could be challenged, as perhaps in the place that the sword pierced the victim's body, there was a perforation in one of the organs that renders the person a treifa, but which was rendered undetectable by the wound caused by the sword. And the Gemara asked, well, with regard to one who engages in intercourse with a forbidden relative, how would they have acted to spare the accused from execution? And Abaye and Rava both say that they would have asked the witnesses, did you see the intercourse? Like a brush entering into a tube, like a mascara brush going into a tube. In other words, well, you saw them having sex, but you weren't like right in the bed with them, so you didn't actually see the penetration, did you? Well, if you didn't see that, that's what we're talking about here is the death penalty offense, and you didn't see in minute detail that happened. Maybe they were just, all over each other, but the penetration wasn't happening. So on the basis of that, we're not going to kill the defendant. We're not going to execute the defendant. So the Gemara asks, and concerning the rabbis who disagree with Rabbi Tarfon and Rabbi Akiva, how would they have adjudicated that case? And the Gemara answers, they hold in accordance with the statement of Shmuel. As Shmuel says, in cases involving adulterers, one can testify and convict them from when they will appear as adulterers. We don't have to witness the actual penetration. We don't hold by Rabbi Akiva and Rabbi Tarfon. There are times when the death sentence is carried out, defendant is sentenced to die, and he is executed, or at least he was, when the Sanhedrin was constituted in the days of the temple in Israel. And that concludes chapter 1 of Tractate Makkos. Now we move to chapter 2. Chapter 2 is all about the Ir Miklat, the city of refuge, the place to which a manslaughterer, a negligent murderer, not an intentional murderer, could flee. And as long as he's in the city of refuge, he's protected from the Goel Hadam, the avenger of blood, who's a close family relative who is authorized to kill the negligent murderer, which is fascinating provision in the Torah, because it makes no sense in the sense that we're so reluctant to have a court which has heard testimony of witnesses, execute a defendant. But the relative who's in hot pursuit and angry because his relative has been killed, negligently, not intentionally, does have the right to kill the manslaughterer. Until the manslaughterer, the negligent killer, right, the manslaughterer, until he reaches the city of refuge, then the avenger of blood does not have that right. We learn that from Deuteronomy 19, verses 2 through 7. You shall designate 3 cities for you in the midst of your land, which the Lord your God gives you to possess it. Prepare for you the road, and divide the borders of your land, which the Lord your God causes you to inherit, into 3 parts, that every murderer may flee there. And this is the matter of the murderer who shall flee there and live. It is one who kills his neighbor unawares, right? This is negligent, not intentional. As he did not hate him from before, And as one who goes with his neighbor into the forest to cut wood, and his hand fetches a stroke with the axe to cut down the tree, and the blade flies off the wood handle and finds his neighbor, and he dies. This murderer, he shall flee to one of these cities and live, lest the blood redeemer, or often translated as the avenger of blood, pursue the murderer while his heart is hot and overtake him, because the way is long, and strike him fatally. And for him, the avenger of blood, there is no sentence of death, as he did not hate him. And for him, the manslaughterer, there is no sentence of death, as he did not hate him from before. Therefore, says God, I command you, saying, you shall designate 3 cities for you. And in Numbers 35, verses 24 through 29, then the congregation shall judge between the murderer and the blood redeemer according to these laws, and the congregation shall rescue the murderer from the hands of the blood redeemer, and the congregation shall restore him to his city of refuge. Meaning, right after the killing happened, the manslaughter fled to the city of refuge, so he wouldn't be killed by the blood redeemer. Then he has to come back for the trial. And the court has to determine, was it an accident? Was it manslaughter? Or was it intentional murder? If it was an accident, the guy can go home. Circumstances beyond his control. If it was an intentional murder, he's going to be executed. If it was indeed manslaughter, he returns to his city of refuge, that he fled there, and he shall dwell there until the death of the high priest who was anointed with the sacred oil. Meaning, it's indeterminate how long he's going to have to live, how long he's exiled to the city of refuge. You could have a very long-lived high priest. This guy could be there, maybe the guy who commits the manslaughter is 50, and the high priest is quite young, and 50 years later, that high priest is still alive. Well, this guy, if he lives to 100, he's still living in the city of refuge. On the other hand, if he has an old high priest who happens to, or maybe has an accident or dies, whatever, as soon as the high priest dies, the manslaughter can go back to his home. He doesn't know how long it's going to be. And if the murderer shall at any time go beyond the border of his city of refuge where he flees, and the blood redeemer finds him outside the border of his city of refuge, and the blood redeemer murders the murderer, he has no blood. For in his city of refuge he shall dwell until the death of the high priest, and after the death of the high priest the murderer shall return to his ancestral land. And these matters shall be for you a statute of law unto you throughout your generations in all your dwellings. Those are the relevant laws. We heard a lot of repetition of until the death of the high priest. And as we know, if there's repetitions, must be for a reason. Let's see what we learn here in chapter 2 of Tractate Makkos. Page 7a still, Mishnah number 1. These are the people who are exiled. Anyone who kills a person unintentionally, whether one is liable to be exiled, anyone who kills a person unintentionally. Now, whether one is liable to be exiled depends on the particular circumstances of the case. Okay? If one was rolling a roller to smooth the covering of mortar that he applied to seal his roof, and what we're talking about here is, imagine like a baking pan, but large and made of stone, so very heavy, and you're rolling this thing on a angled roof. Okay, so if you're negligent with this very, very heavy roller, it could fly off the roof and drop on somebody below. And if that person was killed, the question is, did the one up on the roof, was he negligent enough to be accused of manslaughter and subject to exile to a city of refuge? So if one was rolling a roller to smooth the covering of the mortar that he applied to seal his roof, and the roller fell upon a person and killed him, or if one was lowering a barrel from the roof and it fell on a person and killed him, or if he was descending a ladder and he fell on a person and killed him, in all of these cases, he is exiled. But if one was pulling a roller toward him on the roof, and it fell from his hands upon a person and killed him. Or if one was lifting a barrel, and the rope was severed, and it fell upon a person and killed him. Or if one was climbing a ladder, not descending the ladder, but climbing it, and he fell upon a person and killed him, that unintentional murderer is not exiled. This is the principle. Any murderer who kills unintentionally through his downward motion is exiled, and one who kills not through his downward motion is not exiled. So what they're basically saying is, when you're committing an action that already has a high degree of risk because you're lowering something that could easily, the rope could break and it could drop on someone, then you have a higher standard of care required. And if you kill someone in that situation, you're deemed negligent, manslaughter, you get exiled. On the other hand, if you're in the act of lifting, where you have no reason to think that this thing will break and fall on somebody, right? The reasonable person would say that there was no expectation of danger in that situation, and an accident happened, a terrible accident happened. We would say that this was an accident, circumstances beyond the control of the one at the center of it, and he would not be exiled. He could just go on with his life. That's the Mishnah. We're on page 7b now, the Gemara. The Gemara asks with regard to the principle that one is exiled only if he killed unintentionally through a downward motion. From where are these matters derived? It is derived from a verse, as Shmuel says that the verse states with regard to those exiled to a city of refuge, and he cast it down upon him and dies. Numbers 35:23, indicating that one is not liable to be exiled unless the item falls in a downward motion. The sages taught in a Baraisa derivations from verses written with regard to the unintentional murderer. Unintentionally, in Numbers 35:11, and this is to exclude from exile the one who kills intentionally, right? The intentional murderer, he can't flee to the city of refuge. He is going to be subject to a trial, and he can be executed. Interesting, if we find that he was an intentional murderer, but let's say he wasn't forewarned, right? And or there was some other technical reason why we can't execute him. He doesn't go to the city of refuge. It's not like the next best punishment is exile. He's going to be subject to death at the hands of heaven, but he doesn't qualify for exile. Why? Because being exiled to the city of refuge provides an atonement for the negligent killer, for the manslaughterer. And we don't offer that atonement to the intentional killer. Unawares in that verse, in Deuteronomy 19:4, unawares, this is to exclude from exile the one who kills with intent. So the Gemara asks, why is a derivation necessary to exclude one who kills intentionally? It is obvious that he is not exiled. He is subject to the death penalty. So rather, Rava said, say that the type of intentional killer referred to here is meant to exclude the one who says that it is permitted to kill the victim. Right? The killer believes that murder is permitted in this situation. Maybe it was a crime of passion. Maybe, he caught a guy that molested his child, and he thinks that he is permitted to kill in that situation. Maybe he didn't catch him in the act. He caught him later, and he was convinced that it's true, and so he thought it was permitted, but it's not permitted, right? But this is a person that we would say it's not intentional. He didn't think that he was committing murder. He knew he was killing, but he didn't think that it would be murder. Right? Rava said this is the type of intentional killer to the exclusion of one who says that it is permitted to kill the victim. You might think that. The verse teaches that this person is neither executed nor is he exiled. He doesn't qualify for exile. Because he did kill intentionally, he just thought it was permitted. Abaye said to Rava, if the reference is to one who says that it is permitted, he is a victim of circumstances beyond his control, as he did not know any better. How could that be characterized as intentional? And Rava said to him, this is not a problem, as I say that with regard to one who says that it is permitted, his action borders on the intentional. That's why he doesn't qualify for exile. The Baraisa states unawares. This is to exclude from exile the one who kills with intent. And the Gemara asks, with intent? It is obvious that he is not exiled. He is subject to the death penalty. Rabbah said the reference is to exclude the one who acted with the intent to kill an animal and he killed a person inadvertently, or one who acted with intent to kill a non-Jew and he killed a Jew, or one who acted with intent to kill a non-viable newborn and he killed a viable newborn. Yeah, he's not excused. It's not permitted to kill a Gentile. You shouldn't think that. But what we're saying is, well, he meant to kill this. In fact, it doesn't even matter where it's non-Jew and Jew. If he meant to kill, Shimon, and by accident he killed Reuven, well then, with respect to Reuven, that was an accidental killing. Maybe you could say it was negligent, but he wasn't intending to kill Reuven. He was intending to kill Shimon. So doesn't he qualify for exile? No, because he was intending to kill a person, and that's going to be close enough to intention that he's disqualified from exile and gaining the atonement that exile provides. Maybe we'll be able to execute him, maybe we won't, but he doesn't qualify for exile. The sages taught in a Baraisa based on the verse written with regard to an unintentional murderer. And if suddenly, without enmity, he thrust him or cast upon him any vessel without lying in wait. Okay, that's from Numbers 35:22. Now we look at the phrases. If suddenly, this serves to exclude from exile one who unintentionally kills another that he encounters at a corner. What they're talking about here is somebody who's walking around with a knife pointed straight ahead of him, and he comes around the corner, and he didn't know there was going to be a person there, and he ends up stabbing him and killing him. Okay, but your degree of negligence is so high in that situation that you don't qualify for exile. That's close enough to intention that you don't qualify for exile. Without enmity, and this serves to exclude one who unintentionally kills his enemy, as even if the act appears unintentional, the presumption is that it was not, because his enemy ended up dead. The phrase, he thrust him. This indicates that even if he unintentionally shoved him with his body and killed him, he is liable to be exiled. Or cast, because he didn't hit him with a stone or a weapon. He just shoved him. And he wasn't certainly expecting that would produce a death, right? It was just a shove. So that is like a negligent manslaughter, and he would qualify for exile. And the phrase, or cast upon him, this serves to include, somebody who qualifies for exile, the case of a downward motion that is for the purpose of an upward motion. For example, if one bent down in order to lift an item from the ground, and in the process of bending down, he killed another unintentionally, he is exiled. Without lying in wait, this serves to exclude from exile one who had the intent to throw a stone to this side, and it went to a different side and killed a person. Because he's throwing a stone, it's too obvious that somebody could die from that kind of negligence. So I guess we're not going to call that manslaughter. We're going to call that bordering on intentional murder. And it is written, somebody who throws a rock into a crowd, he didn't know who it would kill, but it was certainly foreseeable that somebody might be killed. That guy doesn't qualify for his exile. And it is written with regard to an unintentional murderer and who did not lie in wait. This serves to exclude one who had intent to throw a stone 2 cubits, and he inadvertently threw it 4 cubits and killed someone. And it is written concerning an unintentional murderer, and as one who goes with his neighbor into the forest, right? The wood chopper, from which it is derived just as a forest is ownerless property, and there is permission for the victim and for the assailant to be there. So too, unintentional murder that occurs in any place where there is permission for the victim and for the assailant to enter there is punishable by exile. The unintentional murder of one who entered the assailant's property without his permission is not cause for the murderer to be exiled. Now, the Gemara cites a related discussion. Rabbi Bahu raised the dilemma before Rabbi Yochanan. If one was ascending a ladder and the rung broke from beneath him, and the rung fell, and the rung itself broke out of the ladder, and it fell and killed a person, So that's downward, right? The guy was climbing, but the rung dropped and killed someone. So do we say this was an upward motion or a downward motion? In a case like this, is it considered an upward motion as he was climbing the ladder and therefore he's exempt from exile? Or is the killing considered a downward motion since the rung fell on the victim? Rabbi Yochanan said to him, in the scenario you described, you already touched upon the case in the Baraisa cited above, the case of an unintentional murder that is performed with a downward motion that is for the purpose of an upward motion. The ruling in the Baraisa is that one is liable to be executed in that case. Rabbi Bahu raised an objection to the explanation of Rabbi Yochanan from the Mishnah, which states, this is the principle: any murderer who kills unintentionally through his downward motion is exiled, and one who kills not through his downward motion is not exiled. And Rabbi Bahu clarifies, with regard to the phrase in the Mishnah, one who kills not through his downward motion, what case that was not already specified does this serve to add? Is it not to add a case like this, and to teach that even though the death was caused by the falling rung, since the assailant was ascending the ladder at the time, he is not exiled? And Rabbi Yochanan replied, and according to your reasoning, that this apparently extraneous phrase serves to include a case that is not addressed explicitly with regard to the previous case in the Mishnah, where it said any murderer who kills unintentionally through his downward motion, what case that was not already specified does this serve to add? Nothing, right? So rather, one may say that it serves to add the case of a butcher. And the butcher we're going to talk about a little bit more, right? A butcher with a cleaver, right? So if he is bringing the cleaver down hard to chop bones, and somehow that cleaver in the downward motion ends up killing a person, yeah, he should have been more careful than that. That does not sound like an unintentional killing. A negligent killing of like the kind of negligence that qualifies for exile. That is reckless disregard, that somehow a person got between, him and the chopping block and he killed him. That borders on intentional murder. Maybe he won't qualify for execution, but he also doesn't qualify for exile. On the other hand, if on his backstroke, the cleaver's behind him and it hits someone in the face that he didn't know was standing behind him, that maybe he should have been more careful about his surroundings. But this would qualify for exile because it's very similar to the axe head that flies off the handle. It's very late, and we're just going to ellipse just a little bit, but they're going to go into the case of the cleaver. But behind him, it could be descending. In front of him, is there ever a case where, it would be considered negligent enough that he does qualify for exile? So the Gemara suggests, just skipping a couple paragraphs, let us, and I'm almost done, questions or comments, get them in now. Let us say that Rabbi Bahu's dilemma with regard to unintentional murder committed by one climbing a ladder is the subject of a dispute between Tanaim. If one was ascending a ladder and its rung fell from beneath him, it is taught in the Baraisa that he is liable, and it is taught in another Baraisa that he is exempt. And what is it? Not that the Tanaim disagree with regard to this. One sage holds it is unintentional murder in a downward motion, and therefore he is liable to exile. And the other sage holds it is an unintentional murder in an upward motion because he was climbing, and therefore he is exempt. But the Gemara rejects this parallel. No, that is not the point of the contention, as everyone agrees that it is an upward motion, and there is no dispute between the sages and the Baraisas. Nevertheless, the apparent contradiction between them is still not difficult, as here in the Baraisa that rules him liable, the reference is to payment of damages. As with regard to one's liability to pay damages, there is no difference between upward and downward motions or between intentional and unwitting damage. You always have to pay the monetary damages. But there in the Baraisa that rules him exempt, the reference is to exile, from which one who murders unintentionally in an upward notion is exempt by Torah edict. And if you wish, say instead that in both this Baraisa and that Baraisa the reference is to exile, and it is still not difficult, as this Baraisa where the ruling is that he is liable, this is referring to a case where the rung of the ladder was worm infested and he should have been cautious before stepping on it. And that Baraisa where the ruling is that he is exempt is referring to a case where the rung was not worm infested. He had no reason to believe that the rung would break, and so we consider that beyond his control. And if you wish, say that in both this Baraisa and that Baraisa, the reference is to a rung that was not worm infested, and it is not difficult, as this Baraisa where the ruling is that he is exempt is referring to a rung that was tightly inserted into the ladder, and therefore he could not have foreseen that it would be displaced. And that Baraisa where the ruling is that he is liable is referring to a rung that was not tightly inserted. He should have seen that the ladder was old, rickety, could break. It was foreseeable, right? So the degree of negligence is all about the amount of foreseeability that is present, that this could end up harming someone. And that concludes our discussion of Mishna number 1 here in chapter 2 of Tractate Makkos. We'll pick it up with Mishna number 2 tomorrow at the regular time for Friday, noon Pacific. I apologize again that I didn't tell you yesterday that today's class would be an hour early. But as I mentioned before, when a situation comes up like that, we'd like to be able to send at least an email to all the regulars who are here every day. So please email us that you would like to be included in such an email group. We won't share people's email addresses with each other. We'll just put everyone in the BCC field. But if you'd like to be included in such an email, most of you have our email address, and just email us that you want to be in that group. And if you don't have our email address, use the contact form at accidentaltalmudist.org and let us know that you want to be in such a group. And so that'll be for if there's any last minute changes of AT daily like there were today. That's what I got. All the best. God willing. See you tomorrow, Friday at noon Pacific. All the best.